I think it also has to do with communication from the top of the organization. Director Peters has delivered what I believe are trend-setting changes for the BOP that just for whatever reason are not being implemented at the institutional level. To go to the cool hand, Luke, it's a failure to communicate, I believe, is the number one issue within the BOP about pushing people out. There's also needs to be an incentive for the case managers. Let me get these guys out of here. Let me send men and women home that don't need a lot of programming, that aren't going to reoffend.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, Doug Passon coming to you, not actually from Studio 3553 today. I'm playing the home version on this lovely Friday morning, but I guess what we're going to do here is one more chapter in the story of a very deeply dysfunctional Federal Bureau of Prisons. And we've been talking about this a fair amount on the podcast, about that dysfunction, the danger, the dehumanization, and we're going to keep talking about it. But today, we're talking specifically about a rather hot topic, which is the First Step Act, and more importantly, the BOP's utter failure, their inability to follow the law and properly implement the First Step Act. So, in order to help us get set for sentencing today, we have a returning champion, Walt Pavlo from prisonology.com. How are you, Walt?
Great.
Welcome back.
Thank you so much, Doug.
Yes, and Walt not only runs this extraordinary prison consultancy at prisonology.com, but he is a regular contributor to Forbes online and mostly, maybe exclusively, writes on these BOP issues. So he's written a couple of articles recently focusing in on the First Step Act. And of course, Walt and I work together, and we've sort of experienced this up close and personal when our clients end up in the Bureau of Prisons and what seems like a pretty simple endeavor to implement, I don't know, the law ends up being a complete clusterfuck. And so that is what we have to talk about today. What is going wrong? What are the issues that we're seeing? And maybe hopefully possible remedies to these? What can we do about it? So let me just throw it to you first of all, because I'm not going to take for granted that everybody listening to this knows what the First Step Act is. So let's just start there.
Sure. So in 2018, President Trump, we can all argue, is one of the most divisive figures in recent political history, worked with Congress and somehow came up with 80% support for a First Step Act that did two things. It allowed prisoners to first earn up to a year off of their sentence, certain category of prisoners. And then it also reemphasized the Second Chance Act from George W. Bush, reemphasizing that we need to return, particularly minimum and low security prisoners back to society sooner. That was the intent of the law. But we really didn't know, even though it was signed in December of 2018, the major provision of the law regarding the reduction of time didn't come into play until January of 2022. And that's when, we first learned that they're really going to get a year off. And that came out in the Federal Register and said, we've, defined what this law is, and this is what the BOP is going to do. Now, the BOP does nothing fast. So, in 2022, it was almost like this is the first time they've seen the First Step Act. And now they have to go through and start this calculation. And it has been one blunder after another in interpreting this law. But more to the point of things that we're going to talk about as it relates to First Step Act and Second Chance Act, the ability to let someone, live in the community, a halfway house or home confinement for up to a year.
Mhm.
There are some severe problems that the Bureau of Prisons is running into. First of all, just calculating the thing. And now number two, that they've done a better job of calculating. They still got some work on that. I'd like to bring up some points on that. There's no place to put them, and they have to put them in the community. And those are through halfway houses. And there's a huge shortage. So, the BOP is starting to iron out some of the past problems that they had with calculating this, who's eligible and getting people to, the reduced sentence. But now comes a time, where do they put these folks? The other component of the First Step Act is there's a reduced sentence, but there's also the provision that once you've gotten the 1 year off of your sentence that actually reduces it, you earn more credits that go toward home confinement. So potentially people that have a 10, 15-year sentence could be on home confinement for 2 or 3 years or more. So there's no cap on that. The BOP's never had anybody in a halfway house for a year, hardly, very few for a year, much less multiple years. So this is adding to the problem. So not only do we have a shortage, every day, more and more people should be leaving the BOP to go to home confinement, but there's no place to put them.
So let me just make sure I got the logistics of the First Step Act right. You could say you earn up to a year off your sentence, and when I think about it, I always just think about it in terms of, okay, if you do the participate in programs, you can earn up to 10 days. Well, let me start by this. Before First Step Act, you only had good time credits, which meant
Correct.
if you didn't get in trouble, you had good behavior, you could earn up to 54 days a year off of your sentence. So really it's 10 months out of a year is what you're serving
Mhm.
if you're good. But then they said, okay, on top of that, we're going to give you this opportunity. If you participate in program and have good conduct, all those things, you can earn up to 10 days a month. And so are you saying there's a year cap on that? It's 10 days a month, but it
There
can't,
is. So it
okay.
actually goes, no, that's a good question. So Doug, actually the way it works is that for the first, let's just assume like a 4-year sentence, the first 6 months of that is you're getting 10 days per month. And then you have your second program review. You have an initial one right when you come in. And when you get
Mhm.
that second one, they go, wow, Walt or Doug, you've been pretty good for this last 6 months. Now you can earn 15 days per month. So in essence, you're earning half a year off of 180 days off of your sentence each year. Kind of once you get past that 10-day first period, it goes to 15 in a full year, that's 180 days a year. So,
Okay.
and
But it's capped at a year either way on that.
capped at a year, but then you keep on earning those credits. Now that goes toward home confinement. Doug, most of the guys that I talk to, give me home confinement. Get me out of
Sure.
here. It's almost like a year off to them, or multiple years off. They get out of prison earlier.
And there's no cap on that aspect of home confinement. So if
No
you have
cap.
like a very long sentence of 10 years, and you've earned 3 years, you've earned your year First Step Back, and you can get out early, you could earn another 3 years in home confinement. Okay, great. But that's just not happening, right? I mean,
That
the BOP has and it's discretionary, right? They don't have to. Do they have to put you on home confinement?
well, under the First Step Act, they do. Under the First Step Act, it says in the law that you shall reduce the sentence, and then you shall put this person in home confinement or halfway
Wow.
house. Obviously, they don't. When there's a requirement like that, it's not good to put the person into a halfway house. They're taking up a bed. If they've earned these credits, it tells you a couple of things. First of all, they're most likely minimum security. They're not a
Mhm.
threat to the community. Their chance of recidivism is extremely low.
Yeah.
So why do you want that person in a halfway house? Most
Yeah.
people have a home to go to. So
Right. And by the way, you're not even eligible for the First Step Back if if you're a certain class of offender. So these people who are violent, there's a whole bunch of exclusions. There's like 50 of them or something like that. But
62 exclusions, the usual suspects, sex
yeah,
offenses, somebody
right.
died in the course of, distribution of heroin,
Yeah.
violent crimes, all that stuff.
And
And
I think
also
that,
previous crimes too, Doug. This is important.
oh,
Let's say that you were a sex offender, there was a sex offender, 10 years ago, and he served a sentence, for 5 years, and now he's out. And then he gets caught in a credit card fraud. He's ineligible for First Step Act credits because of that first offense. So it's either the current offense or any priors, state or federal.
Yeah, so we're talking about only non-violent offenders who have done everything right in custody. And you mentioned taking up a bed, and that bears just kind of telling that story too. I mean, halfway houses historically are for people who really need a place to go. Not all of our clients have stable homes to go home to, or jobs, or the things that you would expect someone to lead a productive, thriving life after they get out of the hellhole of BFP. So they have these halfway houses, and they're a place people can go. They can be monitored. They help them with maybe job placement, maybe whatever they need. And so what's happening here is there's limited space in those facilities. And when there's no room in the halfway house, there's no room at the inn, so to speak. BOP just what? They just shrug and go, sorry, you're going to stay here now.
They've done a better job at doing the calculations right, but they're still having problems with that. So if if you're going to get the year off, they're pretty good at calculating what those are. What they have been lax on, I believe, and against the law, those people that have earned these extra credits for home confinement, they're just saying, well, we'd like to give you home confinement, but there's no room to keep you in home confinement tethered to a halfway house for this year and a half or 2 years. They're just, the contractors want to keep it, but now, that spot is now taken up for 2 years, with the guy that just previously had the capacity. So that's a problem.
Why does home confinement have to be tethered to a halfway house? Why can't we just send you home with an ankle bracelet or whatever?
Well, somebody's still got to call you and make sure that you're in compliance. There's so many problems. I know that we all think like ankle bracelets are like 100% effective. They go off wrong all the time. They fall off. They have to go in and be readjusted because they get too tight. There's a ton of issues associated with that. So somebody still has to monitor the person. It's not like they have no supervision, but you do bring up a good point. The other one is federal location monitoring. It is the ability for U.S. probation to monitor those who are still in BOP custody, but just in doing their supervision. What's unfortunate about that is totally so underutilized. I mean, it really is like approximately 40 people nationally that are on FLM, federal location monitoring. So no
40?
doubt, I'm 40.
And why do you think that is? Is it just people don't understand this is an option, or probation is reluctant to take on the extra burden of supervision, or it just, I mean, 40 is basically nothing. I mean, I don't get
It's
it.
nothing. It's what it has traditionally been, what is being used for now, or in the rare instance that somebody's like in Wyoming or Idaho, and they're 4 or 5 hours from a halfway house, and there's no other way to monitor them, and they've proven that they can be pretty reliable. But the issue is it requires coordination between all the judicial districts, because it is over, U.S. probation falls under the U.S. courts, and what you're trying to do there is, make sure, look, a referral goes into the BOP. The BOP says, we're going to put this person in a halfway house, or they could say, we're going to try the FLM. There just tends to be a lot of pushback. U.S. probation is overworked too. They don't want to have the case. And a shortage of halfway house isn't U.S. probation's problem. It's BOP's problem. So how many more people do they want to take on? My argument is, why not take on all the easy cases? The 80-year-old guy who is doing 3 years for tax fraud. Why not bring that guy on, under FLM? But tremendous amount of pushback.
Yeah, because you're going to house that 80-year-old guy, and you're going to pay not only to house him, which is exorbitant, but you're going to pay all his medical, expenses and everything else that an elderly offender has to take on. It makes no sense at all. And we've talked about. Sorry, go ahead.
Let me just add on that. The elderly offender pilot program expired. It allowed the BOP to put older inmates over 60 on home confinement, when they have done 2/3 of their sentence. It really didn't. When it comes to the First Step Act, you get more credit off of your sentence than you would under underneath that program. But the point that I think that I'd like to emphasize when you're talking about the 80-year-old guy is that guy's probably not even eligible for halfway house. Halfway house usually comes with medical issues and stuff. So now you have an 80-year-old guy who's going to serve inside prison longer than a 25-year-old healthy guy, because that guy can work and he can do all this stuff, but the 80-year-old guy is going to be a pain in the ass. So we don't want him. And, there's no way to get older people out, other than send an 80-year-old guy to live in a halfway house with guys coming out of a U.S. penitentiary. I mean, it just doesn't, it's a solvable problem. It is common sense as you can make it, but they just don't have the will to do this.
Wow. Well, I suppose that might be good grounds for a compassionate release motion if you're an 80-year-old guy and you're getting precluded from halfway house placement because of your medical, all that. But yeah, they make it really tough. I don't understand. And Walt, maybe you can help me understand, why is the BOP so reluctant to clear some of their, clear the halls a bit? We know that most of these places are overcrowded. We know that they have staffing shortages and they're having an amazingly hard time hiring staff. We know that the more people that are in there, the more dangerous, the less ability to program. I mean, why wouldn't they just want to do this push to be like, yeah, let's get these people out. Let's go, let's go, let's go. Is it just about the bottleneck of the halfway house?
I think it also has to do with communication from the top of the organization. Director Peters has delivered what I believe are trend-setting changes for the BOP that just for whatever reason are not being implemented at the institutional level. To go to the cool hand Luke, it's a failure to communicate, I believe, is the number one issue within the BOP about pushing people out. There's also needs to be an incentive for the case managers. We were talking before we went on, like one incentive, if I was a case manager, is like, let me get these guys out of here. Let me send men and women home that don't need a lot of programming, that aren't going to reoffend, that that have all these low attitudes or whatever toward violence and stuff. Get them out of my way and let me focus on the remaining people that are here. That makes common sense, but there's no incentive for them to do that. I mean, there should be an incentive in the BOP, like how many minimum security people are you pushing out, and how many days did you save the taxpayer by pushing that person still incarcerated into a lesser form of incarceration that's much cheaper.
Yeah.
There almost needs to be a task force. If you ask me, and I told this to Director Peters, I believe there needs to be a task force. People come in, look at people, start separating them out and push people out that they can.
Yeah. And figure out a way that you can monitor them without having to tether them to let the halfway house be for the people that really need it, which may mean hiring more probation officers so they can do federal location monitoring. It may be having a whole separate entity that can supervise these folks. I mean, there's any number of ways you could implement it. And we've talked about this before in the context of COVID, when they had to release lots and lots of people to home confinement. We don't have to guess about whether this is a safe, effective program for people to be at home on home confinement, right?
Right.
I mean, what kind of problems did we have in COVID? None is what I
None.
recall you saying.
We slammed the BOP enough. Let's give them credit on that one. 99% compliance of people who went out and completed their sentence without incident. And that is extremely difficult to do. These people have to be in bed every night. They have to take breathalyzer tests. Things that we would just take for granted. Like if somebody said, hey, I just had to run to the drugstore because my mom is really sick and I didn't have time to call in, that gets the person returned to prison, if they do that. So, they're very strict requirements and they were successful. But even with that, we both know that there were a lot of people that didn't get to go home because the BOP seems to somehow have some formula that I just can't figure out that says, well, we're trying to keep as many people in as we can. The judge sent us from the prison and we want them to stay in prison.
Mm-hmm.
Home confinement is prison. I mean, it's prison for, guys that were in penitentiaries. It's prison for the first time white collar offender. It's no different that the BOP says, you know, Doug, I'm going to send you to institution A, and Walt, I'm going to send you to institution B. You know, who cares? The BOP makes that determination. And you know what? They do a good job. Camps are generally filled with nonviolent offenders. There's very few fights. There's no attacks on staff. So they're doing that right. You go to the USPs, you see a lot more trouble. So, you know, their
What
classification system's very efficient.
it sort of harkens back to this idea of whether we sentence people to prison as punishment or for punishment. In other words, it's so overwhelmingly punitive inside the walls of the Bureau of Prisons because there's so much deprivation, and your life is so goddamn miserable every day that it's almost like people saying, "Well, yeah, home confinement, you may have some restrictions on your liberty, but it's not really bad.
Right.
It's not really bad. We need this to be bad because
Right.
you're bad and you need to be punished. You need to be hurt." You know, you need to be deprived of medical care. You need to be isolated from your family. You need to be jacked up on your phone calls and your emails and your commissary and every way we can squeeze $1 out of you. You know, we need to subject you to the dangerous conditions because of understaff, like blah, blah, blah. Like we want you to hurt, and home confinement is not going to hurt you.
Right.
And that's to me the mentality. It's this vicious punishment mentality, and then you get a situation where some of our clients, they have pretty nice homes, and they go, "Whoa, really? Is that a punishment to send you back to your palatial estate in wherever?" But people don't realize that that really is that is a deprivation, just like probation. If someone got probation in a case, they're like, "Oh, they got off with nothing." No, it's not nothing to have somebody watching your every move, telling you where you can go, when you can travel, pee in this cup, you
Right.
know, curfew. Like, come on. All right. Well, I digress. So let's talk about. We've had some firsthand experience, but in your article, one of your great articles, you kind of break down into three categories of people that are getting screwed out
Right.
of their proper amount of first step credits. Can we talk about what these categories are?
Sure. You know, the ones that I see right now that are that are really getting the abuse are the ones that they've earned the 365 days to reduce their sentence. And, you know, because the First Act hasn't been around long enough, now you're starting to have people that have earned well over a year of First Step Act credits toward home confinement. And in addition, the Second Chance Act allows that same person to get up to 6 months of home confinement. And that, you know, again, that was reemphasized in the First Step Act. Like, hey, not only are we giving you this new tool, keep using that old tool. What I've seen is they are getting that first step. They're not even getting the full First Step Act year and a half of home confinement. They're definitely not getting the 6 months under the Second Chance Act. That just has gone out the window, which was almost like, even though it was discretionary, Doug, it was a rule. Everybody, you know, got that home confinement at the end. I mean, it looked more like a rule than guidance or anything else. So those people are really getting hammered, and in some cases violation of the law, because there's not, you know, they're supposed to be going, they shall go to a, you know, home confinement, and they're just not able to do it. The other group that I see that's really being hurt are those with shorter sentences. Let's just say 18 months. Now, when your sentence is 18 months, all your good conduct time, 54 days a year, comes off. So 54 plus 27, 71 some days, or 81 days. That comes off the top. Now you're earning 10, 10, 10. And then after 3 months, because now you're within a year of being released, looking at your projected date, then you're going to go to 15 days. So your out date is much sooner than possible. However, the BOP doesn't have a calculator that looks out into the future. In fact, the day that I walk in, if I have an 18-month sentence, my first team meeting, they should be talking about me going to home confinement or a halfway house, because my sentence is going to be up. Let me give you a real life example. A guy got an 18-month sentence. He's in there now. They've waited to process his paperwork because they're saying, you know what, you're not getting out of here till February of next year. So we put you in for, I'm just giving you 60 days of halfway house. So he gets his paperwork back. First of all, the paperwork that he received was dated 2 weeks from today. I mean, at the top of the paper, the letter was like misdated, hadn't even occurred yet. And the second thing that happened, they gave him an out date, or excuse me, says you're to report to the halfway house on December 30th of this year. And the guy went back and told his case manager, says, I'm going to be out October 10th. Okay, my BOP thing is over with, because they're not looking at that projected release date. That was supposed to go into place in January, because it's, when a person is going to get out of prison, you have to start making, there's all sorts of things that you use that date for. I got to get them into an RDAP class if they're eligible. I got to get them into a halfway house. But if you're thinking the person's not going to get out for, closer to 18 months, and you're not looking at them to see that these credits are really going to happen, people are getting no halfway house.
And let me break that down for people who just to make it concrete. So when you get sentenced, the BOP is going to do an initial release date calculation. So if you got sentenced to 18 months, they're going to say, okay, 18 months from now, is your release date, essentially.
Less some good conduct time.
Less some good conduct time. So they're not anticipating that person is going to earn 10 and 10 every month and then 15 every month. What they're doing is, at the end of the month, apparently, once they've completed their month of programming, then they give them 10. They knock 10 off. They recalculate, right? And recalculate. So they're not just saying, listen, we're going to assume that he's going to earn these things, and this should be the real release date if he earns these 10 and 10 and 15. They somehow are either incapable or refuse to do that, which is causing a lot of fucking problems, because, and what we've experienced is they don't even update it at the end of the month. So you talk about 18 months. Well, we had a client who got 4 months, and what happened is they don't give him any credit until the end of the month. So basically for that last month, he got completely screwed out of 10 days credit time. And which I know a lot of people would say, oh, it's only 10 days. That's significant to anybody.
Yes.
Especially when you only have a 4-month sentence. But they basically held him illegally, in my opinion, because they hadn't gotten around to calculating what they refused to anticipate and give him these credits anticipatorily. But then when it was time to assign them, they were just asleep at the switch. It was well into the next month before they recalculated his score and go, I guess he should have been released already.
Let me tell you another interesting thing about this too. And this is good guidance for attorneys out there. So
yeah, we need it.
If a person goes in on the 15th of the month, right? So the way the BOP calculates it, it says, okay, well, you program for only 16 days during the month. We're going to put those in the bank for you. Okay, they're just going off to the side. So when they do the calculation for, let's just say, you went in the 15th of June. Let's say that when they do the calculation in July, they go, you know what, Doug, you got 0 credits, but you got 15 in the bank. Okay, then the next full month, now you get the first 10. But to your point, when do you ever get that other 15 or 16 days back? Somebody's going to have to manually calculate that at the end, because the BOP doesn't do 30 days of programming and they give you credits. What they do is they pick this calendar date. So what's my advice to attorneys? Have your client show up on the first day of the month or the 30th or 31st day of the month, so that they get, so it simplifies the calculation. And so now they're going to get in. There's no carryover days or very few carryover days, and you get the maximum amount. So if you have a calendar date with 30 days on it, go in on the first of the month. So
that's a great piece of advice. These are things lawyers would never know. And, judge often sets this release date. And well, actually, some districts judge will say, okay, here's your date for self-surrender. And so lawyers, you should be cognizant of that, because the judge would push it 15 days, I'm sure, if you asked her to. But the other districts just say self-surrender when after the BOP classifies you. And then the BOP says, we've classified you, here's your self-surrender date. So what do we do if we get a self-surrender date in the middle of the month from the BOP? How do we get that changed?
I think the most important thing there's a couple of things that you can do. First of all, you can surrender to prison early. Not a lot of people know that, right? Let's just say that they give you a surrender date as the 10th of the month, and you're looking and saying, you know what, if I show up 9 days earlier, they're going to take you. Call the institution, give them a heads up. I'm going to be turning myself in early. You can make whatever excuse that you want to, but they've got to take you. So they're not going
I
to
don't
turn
think
you
many
away.
lawyers know that either. So thank you.
Yeah, yep. And so, I think that the more reasonable way to do it though is to ask for a specific surrender date in the future, like 30 days at a minimum. BOP needs at least 30 days to get the calculation right. So a voluntary surrender of 30, 60, or 90 days into the future, and look at
Ask
your
who?
calendar.
Who are you
Excuse me?
asking? Who are you asking?
The judge. So as part of the judicial recommendation, it would
Yeah.
be, we recommend that he serve his time. I think you should say a specific camp, but you could name a couple of camps, or you could just say in this region, and you would say on this date, and you might say,
Mm.
hey, he's got kids, he's got medical procedures, whatever it is that you would say. That's why we're asking for this date. Don't make it a year down the road, but something reasonable. Judges will usually do that pretty easily. And if not, you wait for the BOP, and if you can, just like I said, show up early.
Mm. Okay.
Can't show up late.
Yeah, that doesn't work out so well. The
No.
marshals come knocking on your door.
Yeah.
Well, there's another sort of esoteric rub to the First Step Act that I didn't know about that you pointed out to me, but it's another good tip for lawyers. So here's my question. What if okay, so let's talk about supervised release. Most people understand that supervised release comes with a prison sentence. Usually a judge will give you a time in prison and then say followed by X years of supervised release, which is basically like probation in the federal system because they don't have parole anymore. So it's usually between 1 and 3 years. And I think a lawyer might say, well, brass ring, if I can get that supervised release thing cut out, because there are some instances where it's discretionary. A judge doesn't have to give you supervised release. So what if I'm the best, greatest lawyer in the world and I've somehow convinced the judge that my client does not deserve to be on supervised release? Judge, don't give him supervised release. Did I just save the day? Am I the hero of all heroes?
For a moment, you might be in your own brain, but the problem becomes on First Step Act. In fact, leave it to the government to come up with this definition. They don't say that they're reducing your sentence under the First Step Act. What the First Step Act reads is like, it's a sooner transition to supervised release. Okay.
Mm.
Whatever reason. But if you don't have a term of supervised release to transition to, you do not qualify for the First Step Act. And
Ah.
so here's so the typical person that doesn't have a term of supervised release is somebody with a sentence of 12 months or less, right? And we all know the difference between 12 months and 12 months and a day sentence, right? You get with the 12 months and a day, you get the 54 days of good conduct time. Even the judges know that. The judges also know that if you get a 12-month sentence, you get no good conduct time. But you can get First Step Back credits on a short sentence below a year if you have a term of supervised release. So in essence, let's just say that you have a 12-month sentence, you're going to earn, I don't know, 75 credits. That's more credits than you would earn on good conduct time, under, the old law. So you're going to get some benefit, but if you don't have a term of supervised release, you don't get any of it.
And so, yeah, so there you go, lawyers. Don't be a hero. As my friend's father was fond of telling us when we'd go off on our little adventures as teenagers, he'd say, "Don't be a hero." So let's not shoot for that. But if anything, if you think your client doesn't deserve supervised release, just ask for the tiniest little term, and that will still make them
Yeah,
eligible.
whatever the minimum, it just, and the rule says a term of supervised release. It doesn't state a term,
Yeah.
I would argue that it's a day, but maybe, but I think they're going to want to put something, but I will tell you, significantly easier. Don't get hung up like this 12 months is going to be so terrible after prison. It's a cakewalk. It is
Yeah.
nothing after the prison experience.
Yeah, yeah. And you can get early termination of supervised release if you're
Absolutely.
doing well and you don't owe a
Yes.
bunch of restitution. I've had clients get terminated in as much as half the, I don't think they're going to do it more than half, but I've had half the time cut off. So All right, so here's a couple other scenarios. Well, this is an easy one that this is like lightning round, but I have a client, and this is clearly an anomaly in terms of the amount of time he has spent in pre-trial custody. In other words, he couldn't get bail waiting, resolving his case or trial or plea or whatever, and he's been sitting in a holding facility pre-trial. And this guy's been in there for several years, which again, that's rare, but 6 months or a year is not unheard of to be in pre-trial custody. Now, if he were, he's in custody, but he's not in the BOP. What if he's in pre-trial custody and he's doing programming there and he's basically checking all the boxes that would ordinarily qualify him for First Step Act credits? Is he earning anything in pre-trial custody?
It depends. Okay. I mean, it's split out there and it's very unfortunate. So this particularly happened when COVID was around. There were a lot of people that were stuck. They got sentenced or something and they just hung out in county jails and MDCs and MCCs around the country
Okay, wait. I'm
to a
sorry to
year.
interrupt. I'm sorry to interrupt, but don't jump ahead to sentencing yet. I'm asking
Yep.
for my clients who had not been sentenced
Got it.
yet. They haven't had their trial or they haven't pled guilty and they haven't gotten that judgment of conviction and sentence from the judge,
Yep.
but they've
That,
been in jail for a year.
yeah,
Credit?
that would be no credit, no credit. That's very cut and dry. There is no credit on that. And there's no law, no cases that I've seen there's been cases that have challenged it. None have been successful. So you have to be sentenced. So people shoot people in 1, 2, 3, 4 years, sometimes before sentencing.
Okay, so let
That's
me
all
just
dead
give,
time.
and that sucks, but I will give a little practice pointer just in terms of the telling the story at sentencing. You need to make sure the judge knows this, because I was just in court yesterday and the judge clearly did not know that and figured there would be a retroactive application of the First Step Act because they did programming. And the law is quite clear, and the BOP is never going to give you something that the law doesn't entitle you to. So you need to make sure the judge knows that and use that as mitigation to say,
Yes.
Judge, it's a fairness, it's an equity argument because he's doing everything right in pre-trial custody. He's done this program. He's been a model inmate. He's never been in trouble, but he's not going to get any credit for that. If he would have done the exact same thing in just in BOP custody instead of this pre-trial custody, he would have earned X amount of days of credit. He would have been eligible for release on this date. Therefore, maybe you should consider giving him less time because you can account for it that way.
Yep, exactly. And sometimes there's good reason. I must say good reasons. There's reasons why his or her sentence has taken place now and not sooner. It could have been the judge's own calendar that they couldn't do it. It could be the prosecutors weren't available. It could be the defense attorney. So it's like, so every day that we couldn't coordinate our calendar, this guy sits in jail doing the things that he's supposed to do, waiting for us to get our shit together, and we weren't able to do it. So, so there's definitely some good arguments to be had there.
Okay, so now there's another rub though, which is First Step Act says once you're convicted and sentenced, you can earn these credits. But we know logistically, after sentencing, you don't make it to BOP right away, unless you're one of the fortunate ones who's allowed to. You're out of custody and you're allowed to report to the BOP. Then the day that your sentence begins is the day you arrive in BOP, and there's no problem. But for that unfortunate group of individuals who are in custody pretrial, then they get sentenced. And then, like you said, the BOP, there's no rule about how long it takes to designate, I don't think. So it's got to go through this whole process at Grand Prairie, find out where we're going to send you. Then we have to do the whole transportation process, which can be rather circuitous and time consuming. So it may be 2 or more months before a client gets from the day he's sentenced to the hallowed halls of a BOP institution.
Right.
What happens in that instance? Does he get credit
Well,
for that dead time?
so the BOP has taken the First Step Act and had its own interpretation of it to say that you don't get credits until you arrive at your designated institution. And so that is a problem, and the prisoner has no control over when they get to their designation. It's not like they could say, I'm going to get the next bus over there. I'm not, I'm going to do these, I'm going to, get over there as soon as possible.
Right.
Believe me, they
I
want
want
to
to
get
book
there.
this flight on Con Air. And by the
They-
way, I would like an aisle seat.
right,
And
right.
I'm a
But
vegetarian, so don't bring me a meal with chicken on the
right, right.
flight.
Well, in my Forbes article, and this, gets to really the third category, right? We talked about the three categories of prisoners who are being hurt by First Step Act, the ones that earn over the 365, toward home confinement, the people that have short sentences. This third group is the group that you're talking about. Their calculations are just sort of like, we're not sure how we're going to do it. So we're going to start their First Step Act when they arrive at the institution. The challenge has been some people are in this, they get lost in the system, or it just takes an inordinate amount of time. They could be in transit for 6, 7, 8 months,
Yeah.
waiting to get to this institution. So some people have challenged it in court, and for the most part, judges agree with the prisoner and say, BOP, the law says it starts once the sentence is imposed. So either send them like a book that they're supposed to read, or that's not up to the prisoner. That's your job to provide the programming opportunities, even if they're in a county jail. And they've won it. And what's interesting, so to answer your question, if a person, they need to file an administrative remedy for the amount of time from the time they were sentenced to the time they arrived at the institution if they're not being given those credits, and BOP is not giving those credits, even though court cases precedent has said that they should. One's been in the District of New Hampshire. The other one, it may have been one like out of Virginia or something.
There
But,
was, let's see, I'm looking at your article. We got a Massachusetts case, which was Vitaly Booker v. Warden Bowers. Yeah, there's a District of New Hampshire and Massachusetts. But yeah, and even in this, the one in Massachusetts, they said, well, he never successfully participated in any programming while he was there. And so why would he earn credits? And the judge basically said, well, that's like YP, that's your problem, BOP. It's not his problem. But the quote you have in there from the judge is, this taking that position amounts to an end run around the plain language of the FSA. So we have a real problem here, because judges are looking at the plain language and says credits start upon conviction. So that's your problem, BOP. But this is not a Supreme Court case. It's not something that applies to every jurisdiction. So BOP says, fuck it. I'm just gonna do what I want. And if I get sued, I guess maybe I'll deal with it later. But the problem is, most inmates don't have the luxury of having a lawyer to take their case into federal court. And you're saying, okay, we'll file an administrative remedy. Well, is that going to be an effective strategy? The BOP can just say no, and then what happens?
But it's hard. It's difficult.
Yeah.
We should do a podcast on administrative remedy. That process is completely broken. When prisoners, the admin remedy is the BP 8 to the case manager, 9 to the warden, 10 to the region, 11 to central office. It's written on triplicate, different colored paper, pen and paper, and there's no
as if we're
electronic
still
message.
in 1960.
It's unbelievable. I think most of them end up in the trash, but
I've literally had my clients tell me that they've seen their case manager throw their BP 9 or whatever in the garbage in front of them. And what are they going to do? No one's going to believe it, right? So,
yep.
well,
But going back to the court cases, one thing that I find it's interesting is that the BOP should do one of two things based on these court decisions. They should change their program statement to allow it that they give them the credits from the beginning, or number two, which by the way, a court judge told them to do it. They willingly gave it to them. These people got released. But the other thing that they should do is, if they feel bad about that, appeal it. We appeal the decision. We don't think that we should have to give these guys that. Why does the BOP has not appealed any of these cases that they've lost? What they do is just give the guy the credits and we'll move on. That's just not fair. the purpose of law, I'm not an attorney, but part of the purpose of law is to act on precedent. It helps us make
Yes,
better decisions. Like, well, how was this handled before?
right.
That shortcuts. We don't have to go through the big, thick briefings and stuff. It's sort of like, hey, that was decided over there. So this is how we're going to do things. The BOP has just kicked that out the window. That's just not happening.
Well, I wish I had great advice for clients who are in custody who need to challenge this and aren't getting any love through the administrative remedy process. There's got to be, I don't know. I don't think the federal defenders have a mandate to take these cases, but that's probably something we got to figure out. Because
But
here's what
I
I
will say
think.
the administrative remedies, though, have to be done anyway. So even if you think they're futile when you're putting them in, you can't get into
Yes,
court unless you go through it. So
yes,
put them in early
yes.
and often.
That's great. That is great advice. And especially for compassionate release, you can't even go to court until you've done the administrative remedy. So,
Right.
well, boy, oh boy, oh boy. We probably have a lot more to talk about, but I think we are at the end of our hour together. So I
Okay.
would just say prisonology.com, Google Walt Pavlo, read all his articles. I'm going to put some in the show notes, the two that you sent me. So if people want to read up a little bit, they're relatively short, easy read, great articles. It's such a great value service that you provide there with these articles. And you recently sent me the and it's a little side note, but it's the compendium from the OIG, the Office of Inspector General, that basically summarizes all the things that are going wrong at the BOP. And it's a link to sort of the exhaustive list of that. I always tell lawyers, you need to tell the story of prison at sentencing. Judges need to be fully aware of where they're sending our clients and how exponentially punitive that punishment can be,
Yeah.
especially for our first time nonviolent offenders. My God, let's stop sending so many people to prison for so long.
The
So,
other thing that I'll add about our Forbes has a paywall. You only get so many free ones, and then they make you pay. Some people have been good enough to do it, but also Forbes has now given me permission that after a couple of days, I can move all of my content, just citing that it was on Forbes, is free and available on prisonology.com.
oh,
So
awesome.
so there's no paywall on prisonology.com, so they can get all
Okay,
those
great.
articles.
Great, great, great. Well, I'll certainly put that link in there, but prisonology.com for sure. And if you need some help, Walt's your guy. And thanks for being here,
Yep.
man. I appreciate you.
Thanks for all that you do. I push this podcast. I mean, you're doing a lot of important work, and there's a lot of important topics out there. And this is our ability. We have paying clients just like you do. This is our ability to share this with everybody and just get the word out
Absolutely.
there.
Absolutely. All right. Thanks, Walt. I'll talk to you soon.
Thanks, Doug.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.